Hey everybody, this is Deb with Truthification Chronicles, and this is a kind of long Twitter thread here that I wanted to share with you, and it's by Undercover Huber. Okay, he's not really Huber, he's not John Huber, or at least not the one that's doing everything and been, working with Horowitz here. But he does come up with some good things once in a while. And so I wanted to share this one with you because this is a good thread. And it basically, he says, here's why Andrew Weissmann is almost certainly the driving force behind Mueller's embrace of a legally dubious theory of obstruction of justice targeting Donald Trump. And he put the rule Donald Trump, which is not really the real Donald Trump, okay? So he's not the real one. It's just, a deplorable that is using that name. Anyway, so let's see what we have here on Weissmann. A redacted version of the Mueller report will be released on Thursday morning, and hopefully this will come out Thursday morning before that happens, if I do things right. So we'll see if it'll make it out before then. And obstruction is likely to be at least half and maybe even the bulk of the report. Here's why Weissmann and Mueller's entire legal case is bunk. Warning, grab a coffee, this is a long one. Or if you're like me, tea. I'm not a coffee person. Anyway, Undercover Huber goes on and says, Mueller's legal theory on obstruction appears to be that Trump may have criminally violated 18 U.S.C. Section 1512C by corruptly influencing or impeding the FBI investigations into Flynn and Russian interference in the 2016 election. And here's what it actually says. Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability to use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. What's really funny to me when I read this is, let's see, who altered or destroyed or mutilated or concealed documents or other objects when she was supposed to be, investigated? Huh? Well, why didn't they get Hillary on this? I mean, you don't smash up stuff and use bleach bit without it fitting this, in my opinion. So anyway, let's go on from there. Trump's alleged criminal acts are apparently his private comments to Comey, hoping he would let General Flynn go. Firing Comey and publicly disparaging the Flynn Russian investigations, and then the special counsel investigation itself as a witch hunt. This isn't just the view of Undercover Huber, but also that of the now Attorney General AG Bill Barr, in a memo he wrote on June 8th of 2018 for Deputy AG Rod Rosenstein. Now, this is before Barr became the AG. I mean, he was just a regular person then, but he was a former Attorney General, so he did have a lot of background in this, and he was sitting back watching what was going on. And so he wrote this memo to Rod Rosenstein and said, look, some things are just not working right. So here's what he says. The president, as far as I know, is not being accused of engaging in any wrongful act of evidence impairment. Instead, Mueller is proposing an unprecedented expansion of obstruction laws so as to reach facially lawful actions taken by the president in exercising the discretion vested in him by the Constitution. It appears Mueller is relying on 18 U.S.C. Section 1512, which generally prohibits acts undermining the integrity of evidence or preventing its production. Section 1512 is relevant here because, unlike other obstruction statutes, it does not require that a proceeding be actually pending at the time of an obstruction, but only that a defendant have in mind an anticipated proceeding. Because there were seemingly no relevant proceedings pending when the president allegedly engaged in the alleged obstruction, I believe that Mueller's team is considering the residual clause in Section 1512, subsection C2, as the potential basis for an obstruction case. Subsection C reads, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, is guilty of the crime of obstruction. Emphasis added. Okay? So that's what he's got here, and then he goes on. He says the section 1512C obstruction theory almost certainly comes from Weissmann because 1. Enron, 2. Aggressive lawyering, 3. First public hints of 1512 came from a Mueller leak, 4. Same statute used against Manafort, 5. Trusted ally needed to convince Mueller to embrace it, 6. Motivation. Now he's going to go through these, so here's the detail on each. Later we'll also get into why 1512C is so legally dubious for Trump obstruction, why Weissmann would be motivated to do it anyway, and even despite it having little chance of legal success. And if you recall from Enron, Section 1512C was enacted in July 2002 specifically to address actions carried out by Enron auditor Arthur Anderson. Weissmann led the Enron task force at DOJ and personally led the prosecution of Arthur Anderson, and so has a close familiarity of that specific law. And if you look here, especially the part that he has highlighted, that's what I'm going to focus on. You can go back and read the whole thing if you want to. I'm going to include the Twitter link to the first one, and it'll have the whole thread there when you click on it. And also I'm going to do the thread reader, which just basically puts everything out like this on a web page, so you can go through and you can read it like that. Okay? Well, I have it kind of blown up for reading purposes. It was for a different one that I read, though. Anyway, that statute was prompted by Enron's massive accounting fraud and revelations that the company's outside auditor, Arthur Anderson, had systematically destroyed potentially incriminating documents. Subsection C was added to Section 1512 explicitly as a loophole closer, meant to address that the existing Section 1512B covers document destruction only where a defendant has induced another person to do it, and does not address document destruction carried out by a defendant directly. And so that's what it was, working with. And then he points out here, this is, the corporate fraud accountability, Title 11 here. And that's what it is down here, the tampering with a record or otherwise impeding an official proceeding, otherwise instructs, influences, or impedes any official proceeding or attempts to do so. Okay, so that's what they're dealing with on this. And if you look here, this is from NBC News. Weissmann's greatest successes and failures came when he directed the task force investigating Enron, a giant energy company based in Texas that collapsed in 2001. The team racked up over 30 convictions in the highly complex case, but one of them, involving the company's outside auditing firm, Arthur Anderson, was reversed by the Supreme Court. Okay. So we go on. Aggressive lawyering. Using Section 1512C is untested, so requires aggressively pushing the envelope of the law on obstruction. Weissmann, uniquely qualified, legally prosecuted Arthur Anderson, destroying the company and 85,000 jobs, later being unanimously reversed 9-0 by the SCOTUS, the Supreme Court. And here's the article that has to do with that. He has screenshots of things. I really appreciate when he does this. So, it kind of supports his argument that he's saying. And this is from May 31st, 2005. And it just, justices unanimously overturned conviction of Arthur Anderson. So, very interesting. And he goes on, here's the SCOTUS ripping Weissmann a new exit hole. And this is the whole thing here. Let me see if I can find it here. And you can look at that too if you want to. It has the syllabus of it, everything. And then they have the opinion by Rehnquist. And you can also listen to the audio of the oral argument and the opinion announcement. So if you want to do that, yeah, there it is. So you can check that. Again, if you just click on this link, in his thread, or it should also appear in the thread reader here. It'll appear there. Okay, anyway, and then here he points out the next one. The first public hints came from a Mueller leak. First public knowledge Mueller was intending to use Section 1512 as the basis of the obstruction was leaked to the New York Times on June 2nd, 2018, with specific attention drawn to Section 1512C. And Weissmann has been known to leak to favorite reporters, the AP, about Manafort, etc. And so if you go through, you see it here, and here they're talking about it. Again, this was from the New York link. And then this part right here, but a different obstruction statute is relevant here, legal experts say. And which one is that? Well, if the link takes you directly to 18 U.S.C. 1512, and that's where it will be talking about, because this original one was talking about Section 1505. And so that was not applicable, but that one was. And so now this was, the article. Details emerge on Justice Department meeting with reporters on Manafort. Lawyers for former Trump campaign chairman Paul Manafort are crying foul over a meeting Justice Department prosecutors held with 4 Associated Press reporters last year as news organizations and the FBI borne down on the longtime lobbyist and political consultant. So, we know that they worked together with, the press. We know that was definitely happening. So, anyway, the New York Times piece, here it is. And the Trump lawyer's confidential memo to Mueller explained. So yeah, it was leaked. It said it was delivered by hand, confidential, and they leaked it to the New York Times. I mean, slimy people. Slimy people. Anyway, so here is the whole thing. It's from the New York Times article. And so, yeah, that's there. That it comes up really weird looking here. I don't know why, but yeah, if you click the link, you can go see it. And number 4, same statute used against Manafort. And Section 1512, and then he has a star here, Section B1 and K, was used to prosecute obstruction charges against Paul Manafort. Weissmann personally led the case against Manafort and aggressively went after him, as well as forcing even his lawyers to testify against him. So yeah, Weissmann was really taking on that Manafort thing. And so then we have number 5, trusted ally needed to convince Mueller to embrace it. Convincing Mueller to embrace this theory and put his reputation on the line requires a very close relationship. And Weissmann was the FBI general counsel under the then FBI Director Mueller, one of his first hires for special counsel team. Wonder why Mueller picked him. Anyway, number 6, motivation. We'll come back to this. Weissmann has a ton of motive. Okay, why is 1512C so legally dubious for a Trump obstruction case? Now AG Bill Barr appears to have written his June 8th, 2018 memo in response to the New York Times leak of a week earlier. Okay, so that was on June 2nd. In part because of how legally dubious the Mueller-Weissmann obstruction theory outraged him so much, it required him to put pen to paper immediately. So he saw the article in the New York Times, this article right here, and he read through it and he said, no, they're trying to set up Trump, and he could see it, and he said, no, it's not right. And because it ticked him off so much, he wrote a letter. And this was the article, of course. And then he wrote a letter, a memorandum to Rod Rosenstein and the Assistant Attorney General Steve Engel. And so, yeah, and it was about Mueller's obstruction theory. So he wrote a memo about that. AG Barr says Mueller's embrace of 1512 as a basis for obstruction is grossly irresponsible unless there is an underlying crime of conspiracy collusion to obstruct. There wasn't and isn't any collusion crime, as now admitted by Mueller. So, see, this is the thing. Barr spoke out before he even became AG, and he was sitting back just as a regular guy, and he was reading the news, and he said, this is not right. These people, no, no, no. So here's what he says here. For reasons discussed below, I do not subscribe to this notion, but here it is largely an academic question. Either the president and his campaign engaged in illegal collusion, or they did not. If they did, then the issue of obstruction is a sideshow. However, if they did not, then the cover-up theory is untenable. And at a practical level, in the absence of some wrongful act of evidence destruction, the department would have no business pursuing the president where it cannot show any collusion. Mueller should get on with the task at hand and reach a conclusion on collusion. In the meantime, pursuing a novel obstruction theory against the president is not only premature, but because it forces resolution of numerous constitutional issues, grossly irresponsible. And you see this particular, comment that he made here, this memo that he wrote, this was putting out his ideas. And this was one reason why the Democrats were not too thrilled with him, was because they knew he had written this memo. So they knew if they tried to get Trump on obstruction, he was going to stand against that. And that's why it really was no surprise to them that, maybe Mueller said it was dubious on this whole obstruction thing, but he was going to leave it up to Barr. Well, Barr, obviously, because he already had taken a stance, we knew he was going to rule that way. So, anyway, question. If Barr thought Mueller was being grossly irresponsible, which is what he said in that memo, way back in June 2018, what do you think he thinks now, after Mueller left collusion dangling through the midterms, and now he's AG? Why did Mueller and crew pack their bags again? Barr also eviscerates the use of 1512C, so legally unsupportable it is inconceivable that DOJ could accept anything so untenable. Full memo is here, and so I will have the link down below to the full memo. Here it is, and you can read the whole thing. It's 19 pages long, so yeah, you can read that. And he just basically, that's what he says. It's inconceivable to me that the department could accept Mueller's interpretation of 1512C2. It is untenable as a matter of law and cannot provide a legitimate basis for interrogating the president. I know you will agree that if a DOJ investigation is going to take down a democratically elected president, it is imperative to the health of our system and to our national cohesion that any claim of wrongdoing is solidly based on evidence of a real crime, not a debatable one. It is time to travel well-worn paths, not to veer into novel, unsettled, or contested areas of the law, and not to indulge the fancies by overly zealous prosecutors. So again, when he wrote this, he was just a regular person. Okay, he had no legal standing to make any decisions at that time. However, that's what he had to say then, and so I doubt if he's changed now. And that's where he's going to stand, and that's why he made the ruling that he did on the whole obstruction thing, because it's just not a legitimate thing. And there are multiple federal statutes for obstruction, and none of them apply to this theory with Trump except this Section 1512C, which has never been used for a situation like this. Barr didn't cover these in his memo, so here's a Huber summary. And let me see if I can find that. Yeah, here it is. Okay, so this is just a little bit bigger here, so you can see it. And the gray shading ones are the ones that don't apply to Trump at all, like obstructing process server, not applicable, no process server involved. Influencing or injuring officer or juror generally, and that's not applicable. FBI investigations are not judicial proceedings. That's kind of an important thing too. And so it goes through, and no bribery or interfering with subpoenas. And these are the only ones that could possibly, but even, the Ninth Circuit has held an FBI investigation is not an official proceeding. But, he wasn't tampering with a witness, victim, or informant. Because when he talked down here, retaliating against a witness, victim, or an informant is part of it too. And it says, well, likely not applicable as Comey was not a witness within the scope of 1513. It cannot be a crime under Article 2 to retaliate against an FBI director by removing him. So see, he had to be a witness, a victim, or an informant, and Comey was none of the above. So when he was fired, it had nothing to do with obstructing justice. And then also down here it mentions George Papadopoulos was originally charged with obstruction under the statute for deleting his Facebook profiles after an FBI interview. This was later dropped under his plea agreement. So, that's what this one is. It's just hard to see here, and when you pull it up, it doesn't get much bigger. So, anyway, that strongly suggests that Weissmann wanted to find the crime of obstruction and went through every statute to find something to pin on Trump, regardless of how shaky it was. Which, that's what Weissmann, I think, was put in there to do, honestly. Also, Section 1512C was originally enacted in 2002 to address corporate fraud with the example case of document shredding, and not anything like the situation with Trump, Comey, Flynn, as even the New York Times admits. And so, it just talks about this, and they mentioned that that's what it was for. And again, it was introduced as an amendment by Senator Trent Lott in 2002, and they were doing it would enact stronger laws against document shredding. And so really that's what it was for. And then down here at the bottom, the legislative history thus confirms that Section 1512C was not intended as a sweeping provision supplanting wide swaths of obstruction law, but rather as a targeted gap filler designed to strengthen prohibitions on the impairment of evidence. So this is what it was for, and the thing is, they're trying to make it into something it wasn't. And so the DOJ's U.S. Justice Manual describes 1512 as protecting witnesses, victims, or informants. And that's very interesting that it says that. Here's what it says. I mean, this is it. Protection of government processes, tampering with victims, witnesses, or informants. And that's the 18 U.S.C. 1512. I mean, that's what the whole purpose of it was. Well, Trump did not tamper with any victims or witnesses or informants. I mean, he didn't try to stop any of them from saying anything. He obviously didn't get rid of any evidence because he provided like over 1 million documents. And so they really just don't have a case on this. But that when this comes out tomorrow morning, that's what they're going to be focusing on. It is. Anyway, and that's why I wanted to get this out. Again, I probably won't get it out before the actual thing. I don't know. I'm going to try, but it may not quite get out in time. But that's what I think is probably going to happen. Anyway, Section 1512 requires an official proceeding for the crime to even apply. And we talked about that it's with Section C, the only part even theoretically applying to an FBI investigation, which the DOJ agreed with in the Ninth Circuit, and Ermonian is one of the people that was involved in that. And that's what this is talking about, that it might possibly apply to an FBI investigation, but they've been trying to say that no, it's not necessarily a proceeding. So the most recent U.S. Court of Appeals rulings, 5th Circuit 2008 and 9th Circuit 2013, hold an FBI investigation is not an official proceeding. The 9th in Ermonian is one of the cases. Okay, it's a person in one of the cases. Was explicit. An FBI investigation is not an official proceeding under this 1512 obstruction of justice statute. So that's what this says. And these were the defendants in that particular, case. That's how they refer to them. Ermonian and Johnson were charged with conspiracy to corruptly obstruct, influence, and impede an official proceeding, to wit, a law enforcement investigation conducted by the Federal Bureau of Investigation. And so it went back and forth, but yes, it was decided that no, the district court in this case instructed the jury that an official proceeding includes an investigation by the Federal Bureau of Investigation. As we have already determined, such instruction was legally erroneous. An FBI investigation is not an official proceeding under the obstruction of justice statute. So, anyway, it goes on. He says, I can't find any federal appeals court that has specifically held that an FBI investigation is in fact an official proceeding within the meaning of 18 U.S.C. Section 1512. None. Some have held other investigations are, but not FBI ones. Weissmann, if you're reading this, at me, dude. Oh, bottom line, if those Fifth and Ninth Circuit positions hold, then it is legally impossible for Trump to have committed a crime under the statute by obstructing an FBI investigation. He couldn't even do it as a private citizen, never mind as POTUS. Even if SCOTUS, which is the Supreme Court of the United States, reversed the Fifth and Ninth unlikely, according to the DOJ Justice Manual, again, 1512C requires the defendant to intend specific results. For example, preventing a witness from testifying at an official proceeding, essentially a form of a specific event. And that's what it has here. It says basically the same thing. Trump hoping for Comey to let Flynn go is not a specific result and cannot possibly apply as Comey wasn't a witness, victim, or informant at the time, which is the clearly intended meaning of the statute. If you want to take down a democratically elected president, you'd better do it with a real crime, not a novel, untested, and contested idea cooked up by overly zealous prosecutors. Weissmann, that's you. Bye. And here's an NPR link if you want to go to that. The NPR link is here. So, and you can listen to it even if you want to. So the links are all going to be down below and you'll be able to check those out. So anyway, and Andy McCarthy even, said, that's very interesting. He said, and don't forget that this was supposed to be a counterintelligence investigation, and that would not even fit anyway. So that's another thing, and he responds by saying, strongly suspect this is why General Counsel Baker was trying to blur the line on this in his congressional testimony, saying that this investigation was always both a counterintelligence and criminal probe from inception, obviously highly irregular. So yeah, that's it. That's what I've got for you on this one. Lots of fun things, and I'll tell you, it's very interesting what he puts down here, and I just don't think there's going to be any way they can make a charge of obstruction just stick. I mean, it's not going to. And that is probably the only thing the Democrats will be able to hang on to and focus on. So I don't know exactly what's going to come out in that Mueller report. I don't know what things are not redacted. I do know he said he was going to redact things that had to do with people who were not charged. And since Trump was not charged with anything, I would think that would have to be redacted. But I don't know if that's how it's going to work. I mean, obviously he's going to try to put out as much as he can. The Democrats will not be satisfied. I'll tell you that right now. If I were a betting person, I probably would bet on that they just are going to still be unsatisfied with everything. It's not going to be enough. And honestly, if they had the whole report, it probably still wouldn't be enough. All they want is something so bad that they can get rid of Trump because they're desperate. Now remember, the whole thing is these people are desperate. They cannot allow him to continue what he's been doing because he is exposing this corruption. And the people who are guilty of this corruption can't allow him to do that because they know they are going to be tried for treason when all this comes out. I mean, Trump's known about it for a long time, and he's just been waiting for it to get out there enough so that people will see it. And that's really where we're at right now. It's all starting to come out. It may still take a little while, but it will happen, and there will be prosecutions. So that's what's in our near future. They're trying to do it in a way that it's not going to just destroy our entire government. And because it is really goes to the heart of what our government is all about, and it undermines everything. So that's why they're trying to be very careful about it and to kind of attack it strategically so that these things come out in little bits and pieces. More people are waking up and are starting to see the truth. And that's what we need to have. I realize people are not interested in optics, but you've got to be. Okay, we really do have to understand that optics plays an important part. It can't look like this is, a political party targeting another political party, because it's not. It's about stopping the corruption. It's about justice, where the rule of law is applied equally to everyone, no matter what their last name is. And that's what we want to see done. So when you're talking in the comments, I understand some of you are a little, upset about all this, and I am too, but try to remember to keep it decent, okay? Just for my sake, because I don't know what they're doing. They are doing some weird things with comments lately, and I think they're monitoring them. So it would be better for me if you would just, we want justice done, okay? Focus on that. We want justice done. Now, what the penalty will be for their actions, let's not focus on that right now. Let's just focus on we want justice done, okay? So I would appreciate that. Anyway, that's what I've got for you on this one. The links will be down below. You can read them at your leisure, or the thread roll will be there. You can just read the whole thread. So that's all on this one. I want to thank you for stopping by, and I'll see y'all later.